Before you add your child to your bank account, you need to watch this video. A lot of people think that adding their child to their bank account is a smart and practical decision. You may be thinking, if something happens to me, my child can help out. And when I pass away, everything just goes to them easily. It sounds simple, it sounds efficient, and it sounds like good planning. But this is one of the most common mistakes I see, and it can create serious problems for the family. I'm attorney Otto, a Florida estate planning attorney, and I want to walk you through what's really happening when you do this and what to consider before you make that decision. Now, first, let's talk about what people think they're actually doing. Most people have really good intentions here. They're usually trying to make things easier. Maybe they want to help their family member out, or they want help managing their finances. Maybe they want to avoid probate, or maybe they just simply want a way for their money to go to their children when they pass away. And again, none of those goals are wrong. The issue is not the intention. The issue is how the law actually treats that decision. Because when you add your child to your bank account as a joint owner, you're not just giving them access, you are actually giving them ownership. That means the money legally belongs to the both of you, not just you anymore. And that's where things can start to go sideways. Now, let's talk about what you're actually creating when you do this. First, you're exposing that account to your child's financial life. If your child has debt, if they get sued, if they go through a divorce, that account can potentially be pulled into all of those issues, even if the money was really entirely yours. Now, the next thing is that you have to consider control. Once someone is a joint owner on the account, they typically have the ability to withdraw money from that account. Now, most children would never do anything inappropriate, but that's not the point. The point is that legally they can. And I have seen situations where that creates confusion, tension, or unexpected outcomes. Now, the biggest issue, and the one I see most often, is what happens after you pass away. Let's walk through a simple example. Let's just say you have 3 children. You add one child to your account just to help out, and everything seems fine. Then you pass away. Now, what do you think the bank is going to do? The bank looks at that account and says, this belongs to the surviving owner. That one child gets all the money you left in that account, not because you intended to give it all to them, but because that's how the account is legally structured. Your will does not override that. Sometimes people say to me, well, I added this person to the account, but in my will, I said that it should be divided equally. That is not going to fly. Now you have created a situation where one child receives everything in that account and the others receive nothing. And that can lead to confusion, conflict, and sometimes permanent family damage. Now, another thing people ask me is, well, what if I just give my child access to the account? I can just give them my bank login, for example. And I understand why people would think that. Practically speaking, it might seem easier, but that does not create legal authority. It does not protect you, it does not protect them, and in some cases, it may even violate the bank's policies. So while it may work for you informally, it does not provide a proper legal solution. So now comes the big question, what should I do instead? Now, if your goal is to have someone help you during your lifetime, a better option is a durable power of attorney. That allows your child to step in, assist with your finances, and help manage things if needed without giving them ownership of your account. If your goal is to pass the money after you pass away, then a payable on death beneficiary or designation is usually a clearer option. That allows the money to go directly to the person or to the people, more than one persons or people that you name, without giving them access while you're alive. And for more complex situations, especially if you want to control how money is distributed among multiple people, a trust may be the right solution. The key takeaway here is this. Adding your child to your bank account may seem like a simple fix, but legally it can create consequences that are very different from what you intended. You may be exposing your money, you may lose control, and you may unintentionally change how your assets are distributed. So if this is something you're considering or something you have already done, it's worth taking a closer look, because small decisions like this can have a big impact on your family later on. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.